Ladies and gentlemen, we're ready to start. Our topic this morning is the treaty power, and we have four excellent speakers. None of us knew prior to a moment ago what it is that the four speakers were going to address. It is my job, I gather, to listen to what they say, to try to extract points of differences and exploit them, but not to assert any positions on anything myself, which Rocky tells me is improper. I will introduce the speakers not all at once, but as they speak. And the first speaker is the legal advisor of the State Department, former district judge, former professor at Columbia Law School, continuing scholar on the relationships between the executive branch and the Congress on a broad range of questions. And if I think, as any newspaper reader can determine, the point man, if you will, for the administration in a fascinating dialogue between the administration and the Senate with respect to how one goes about interpreting a treaty of no little importance today, the ABM Treaty. I introduce our first speaker, Abe Sofair.
Good morning, ladies and gentlemen. Thank you, Judge Silberman, fellow panelists. If you see me stumbling around, it's not because in the course of my role as point man, I've been physically damaged in any manner. It's because I got home last night from The Hague, where we were arguing a case to try to prevent the U.S.-Iran tribunal from giving the Iranians a destroyer, which would have been an interesting turn of events, and other military equipment. And in a state of exhaustion, carrying 3 bags at the door, my 6-year-old daughter leaped into my arms. But I'm here nonetheless because I am so delighted to be part of this panel and part of this conference. The treaty power is a unique form of lawmaking. I have a fairly long paper here, which I'm not going to read because I've been told that I have a limit. But I would like to put the ABM treaty debate into some historical perspective. From time to time, the treaty power does provide a forum for national debate on fundamental issues. When that happens, the conflict, I would submit, takes the form of arguments about the treaty process itself, in addition to the usual arguments about the merits of the particular issue being considered by the Senate. Now, treaties are more frequently used for ordinary run-of-the-mill things, and generally speaking, they go through without even comment on the floor of the Senate through the unanimous consent procedure. But every now and then, a major issue arises, and the results of a debate that ensues may distort the treaty process and disrupt accepted treaty practices, at times threatening the utility of the treaty-making mechanism. Now, this hypothesis, I will be very honest to admit, is colored by recent personal experience. The President's Strategic Defense Initiative has been the subject of extensive public and congressional analysis and discussion, and the proper interpretation of the 72 ABM Treaty has long been a controversial subject, but it became more so after this administration concluded in late 1985 that an interpretation was fully justified by the treaty and its negotiating record that allowed increased flexibility in developing and testing mobile systems or components based on what the treaty calls other physical principles other than those used in 1972 ABM systems. The administration's considered legal judgment, based now on painstaking study, is that the Soviets did not agree to be bound in the ABM Treaty by U.S. proposals that would have banned entirely the development and testing of mobile, including space-based devices, based on other physical principles. Despite that fact, however, the President has not implemented the so-called broader interpretation, and he has not even decided when and on what conditions he would implement it, and he has promised Congress that he would consult before making the decision as to implementation and whether he would implement it with or without the Senate's prior consent. Nonetheless, the nation has been subjected to a massive dispute over both the merits of the broader interpretation and the President's power to interpret it without the Senate's consent. Now, while it might be tempting for me, and I often see this happen in politics, to claim that the ABM debate reflects some unprecedented, unjustifiable, incomprehensible phenomenon in American constitutional history, the fact is that the Senate has guarded and aggressively expanded its prerogatives whenever it was politically convenient to do so. The ABM debate, in fact, illustrates a recurring phenomenon in the historic tug-of-war between President and Senate. Technical treaty law issues and questions of competence become the surrogates for policy disputes as politics perverts process. Professor Holt, a scholar of the history of American treaty law, described this phenomenon years ago. Quote, "When a treaty is the subject of a contest in the Senate, the constitutional distribution of the treaty-making power between the President and the Senate becomes involved, and the treaty is certain to be attacked on the grounds that the prerogatives of the Senate are being invaded by the President." Let's look at some illustrations. In the Panama Canal Conference discussion, John Quincy Adams at that time had lost both houses of Congress and attempted to send some negotiators down to discuss what arrangements could be made to protect the American republics from foreign intervention. The Senate insisted on reviewing and clearing the instructions that those negotiators would get. In 1888, in connection with a treaty with the with the United Kingdom concerning the Northeast fisheries, anti-British feeling was very high in the country. The treaty offered a peaceful solution, but the opponents, on a strictly partisan basis, killed it in the Senate. And the arguments related to the treaty power figured prominently in the attacks on the treaty. The particular deficiency cited on this occasion was that the President had failed to get Senate consent to the negotiators whom he chose to negotiate that treaty. Here's what Senator Chandler said at that time. "A treaty so negotiated was a gross violation of the Constitution, willfully, recklessly, and defiantly perpetrated, and the Senate might well have refused on this ground even to consider the terms of a treaty thus introduced into its presence." Well, it was clear in 1888, as it is today, that Senator Chandler's attack was unwarranted and unfair. Presidents before, indeed since Washington, and after Cleveland have often employed treaty negotiators who did not receive the Senate's advice and consent. The Senate nonetheless used this alleged principle to defeat the treaties. The Treaty of Versailles is another example, of course, a major event in American history. And the point about this treaty that I think is worth talking about, and which non-lawyers who discuss this treaty don't spend very much time on. And that is the killer amendments, the killer reservations the Senate put upon the Treaty of Versailles. One of them was cited by Senator Sherman, and his claim was essentially that the president was proposing to do something that would allocate to a foreign institution of some kind powers that exceeded, that really were inconsistent with the constitutional authorities. Another argument Senator Reed made was the call for freedom of transit and for equitable treatment of international commerce was unconstitutional. He said, freedom of transit and equitable treatment for the commerce of all states? What does that mean? What can it mean except that the League proposes to regulate international commerce as the Congress now regulates interstate commerce? How can Congress regulate commerce with foreign nations and at the same time the League be the instrumentality to secure equitable treatment? Clearly the provision is unconstitutional. And a final one was a final reservation that was actually adopted by the majority related to the U.S. power to unilaterally withdraw from the League. And here's what the senator said about that. The United States, actually this was the reservation, the United States shall be the sole judge as to whether all its international obligations under the said covenant have been fulfilled, and notice of withdrawal by the United States may be given by concurrent resolution of the Congress of the United States, thus reflecting the intent of the Senate to keep the president out of the very process of termination of a treaty, a process that historically has been, of course, well within his authority. And another reservation yet required that anyone sent to the League as a participant representing the United States would be appointed by and by the Senate itself and sent by Congress and not by the president. Now, we had a similar fight in 1932 and thereafter, right up to 1954, in connection with the Great Lakes St. Lawrence deep waterway. And the part of this story that I'll tell you, I don't want to take too long here, but I spend a few minutes with you. I think these little stories are worthwhile, really. But the part that appeals to me, of course, is the beating that the legal advisor at that time took. He was also a former judge named Hackworth, and he served the longest period as legal advisor because he happened to be there under Roosevelt. And of course, Roosevelt had 4 terms, so the legal advisor was around for a long time. And Hackworth testified that this plan, which they couldn't get through the Senate with 2/3 of a vote, this plan could be adopted by legislation. Well, the chairman of the Senate Foreign Relations Committee asked Hackworth, how could this be? How could you do through a law what really should be done through a treaty? Would the consent of the Congress, make the leopard change its spots? Well, Hackworth, who was inclined to be intellectually honest, said, yes, it would. The leopard would change its spots if Congress chose to approve this agreement as legislation, which was entirely appropriate statement, because after all, if both the political branches agreed this was a way to handle this matter, who was to say that it wasn't? But Senator Bailey said he found that explanation as convincing as the difference between a 4-legged horse and a quadruped in the nature of a horse. And the subcommittee, in reaction to this outrageous testimony by the legal advisor, called a professor from Yale, Borchardt, as a witness and introduced a legal opinion from Professor Borchardt concluding that the St. Lawrence project could be concluded only by treaty. He urged, this is Borchardt now, urged the Senate to stand on its constitutional prerogatives, warning against giving the House any role in treaty making. And here's the statement Borchardt endorsed. The Senate's treaty power is probably the last remaining bulwark of our national safety, even more, perhaps, than our armed forces. And it should be fought for and maintained at all costs. The legislation, I'm happy to say, was approved. Now, the recent conflict between the Senate concerning the ABM Treaty is also a political debate that has in large part taken the form of claims that the executive is planning to violate established treaty principles. In fact, however, members of the Senate, not the president or the legal advisor, are challenging basic assumptions and recasting basic treaty principles. I have 3 examples here, which the chairman, I'm sure, is not going to let me give you. But I will start with the first and see how far I get, and if I'm asked any questions, I'll give you the second and the third. The first example is, I ask you to consider the so-called ABM Treaty Interpretation Resolution recently proposed by the Senate Foreign Relations Committee, which seeks to require the President to continue to adhere to the restrictive interpretation of the ABM Treaty. Now, we told the committee of the 14 Diamond Rings case, which holds that the Senate cannot affect the interpretation of a treaty by a resolution passed after it has given its advice and consent. Yet the committee majority has adopted a resolution that sidesteps, or tries to, the 14 Diamonds case by saying that the President can only interpret treaties as they were understood by the Senate when it voted. Now, does that mean that the Senate must have passed an understanding? If it does, I agree with it. But that's not what it means. The Senate, says this resolution, can record an understanding even though it's unrecorded by acquiescence in any executive branch statement during the ratification process. The resolution then concludes that the development and testing of new systems based on other physical principles is inconsistent with such a Senate understanding by acquiescence in a handful of statements by non-negotiators on an issue having no conceivable bearing at the time on the Senate's advice and consent. And according to Section 8 of this resolution, such activity, quote, would be inconsistent with the provisions of the treaty and would require an amendment of the treaty. That is, an interpretation, a broad interpretation would be inconsistent with the treaty. And here's what the committee asserts. This section does not constitute a Senate interpretation of the ABM Treaty. The interpretation of the treaties is the President's prerogative, so long as he interprets a treaty within constitutional parameters. Section 8 is a declaration as to how that treaty should be interpreted. And this in a Senate Foreign Relations Committee report. Nothing new, that's my point. Now, the result, though, is an unprecedented interference with the President's power to interpret treaties inconsistent with treaty practice and a Supreme Court precedent that's right on point. Can I give a second?
1 second.
A second illustration.
Oh, I thought you said you were going to take a second.
Uh,
I think your time has expired.
The other 2 illustrations I have are, first of all, Senator Nunn's assertion that, and I can go into detail here because I have some very interesting material that I've dug up to show how untenable it is, that the Soviet Union and other foreign countries understand our treaty-making process so well that when an executive official says something to a Senate committee about the meaning of that treaty, we thereafter can confront the Soviet negotiators and say, aha, but you were there. You were at that committee hearing, or you read, I know you read our Senate committee reports and our testimony, and therefore you are bound because you didn't object. There's absolutely no basis for that interpretation. We rejected it early this century in connection with a German effort to do the same thing about our position. And what's astonishing about this is, and of course we didn't know it at the time, was Jerry Smith testified on another point, the meaning of development, in those same 72 hearings. And in 1981, Fitzgerald, who was another negotiator, argued to the Soviets, hey, you heard what Jerry Smith say about the word development, its meaning, and you didn't object. And the Soviet negotiator said, why should we have to object about something that goes on in your internal processes? So there is a theory of the treaty interpretation process that has been rejected by both the United States and the Soviet Union and is advanced as a basis for the interpretation of the ABM Treaty. I can only say, ladies and gentlemen, since I'm being cut short mercilessly here, that both sides in this debate are going to utilize argument and are going to behave, no doubt, the way Senates and executive branches behave throughout American history. But let's keep our wits about ourselves. Let's not get carried away in overstatements, in political rhetoric. This is a hard-fought debate over the president's power. At a minimum, let's wait till he exercises that power before we restrain him, and particularly in connection with his negotiations that are ongoing right now with the Soviet Union, and on which the number at which the strategic weapons will be set is going to be determined in large part by the president's strength at the bargaining table. I thank you very much.
Our next speaker is Professor Harold Koh, an associate professor at Yale Law School, where he has been an associate professor since 1985. He teaches a variety of subjects, which include legal aspects of American foreign relations. He graduated from the Harvard Law School, and he clerked for Judge Malcolm Wilkie on our court, and then for Justice Blackmun. He's worked at Covington and Burling and the Office of Legal Counsel. His topic today is whatever happened to the treaty power, a Neo-Federalist account.
Thank you, Judge Silberman. Judge Sofair referred to one of my distinguished forefathers at Yale, Judge Borchard, or Professor Borchard, who came down to testify against the executive on the treaty power. Another member of our panel, Professor Rees, wrote an article a few years ago where he said that whenever the Federalist Society proposes an idea, busloads of professors from Harvard and Yale come down to claim it unconstitutional. Well, I didn't come by bus, I drove. But mindful of that background, let me say that maybe the real title of my speech should be Here We Go Again. It seems particularly appropriate and timely that the Federalist Society should address this subject of the treaty power, because I can think of no area of separation of powers law where recent executive practice has moved further from the framers' original intent. Now, Judge Sofair has presented you with one version of how the treaty power has evolved over the last 200 years. Let me present a somewhat less sanguine Neo-Federalist account of what happened to the treaty power over the last 2 centuries, and during this administration in particular. My thesis in a nutshell has 2 parts. First, that during the last 200 years, but particularly since this administration took office, the executive branch, not Congress, has increasingly dominated the process to the near exclusion of the other 2 branches. And by the treaty process, I refer to 3 different phases, what I'll call treaty making, treaty breaking, and treaty bending, under which I'll include treaty modification of the type which occurred in April of 1984, when we temporarily modified our acceptance of the compulsory jurisdiction of the International Court of Justice, and treaty reinterpretation, which the administration has advocated to try to accommodate the ABM Treaty with the Star Wars Initiative. Now, my second and more important point is that the executive branch's current domination of the treaty process, with only limited participation by the other branches, not only runs counter to the Federalists' original intent, and so in this sense, the Neo-Federalists have not well served the Federalists, it has also disserved the long-term interests of the presidency and the nation, even if it has appeared to serve this president's short-term interests. Now, to support my thesis, let me briefly review the framers' original intent to the extent that we can glean it with regard to these three aspects of the treaty power: treaty making, treaty breaking, and treaty bending. Now, with regard to treaty making, the historical record strongly suggests that the framers, the Federalists, drafted the Constitution with two goals in mind. First, to establish the supremacy of the federal treaty power over the states, and second, and equally important, to ensure that within the federal government, both the President and the Senate would participate before a treaty is concluded. At various points in the Constitutional Convention, thought was given to giving either the Senate or the President alone the treaty power, but Hamilton, Madison, and Jay all urged the Convention to adopt the current version of Article II, which gives the President the power, by and with the advice and consent of the Senate, to make treaties provided 2/3 of the senators present concur. In James Wilson's words, this compromise was to guarantee, quote, that neither the President nor the Senate solely can complete a treaty. They are checks upon each other and are so balanced as to produce security to the people. Writing from Federalist 75, I don't have a nice red hardbound version of the Federalist, but I do have this cheap paperback. The words, I think, are the same. Hamilton concluded, quote, "It must indeed be clear that the joint possession of the treaty power by the President and Senate would afford a greater prospect of security than the separate possession of it by either of them." Now, with regard to treaty breaking and treaty bending, the text and constitutional history of Article II are silent, but a careful reading of Federalist 64 suggests that the constitutional design reflected not only a legal judgment by the framers, but also a prudential judgment about what a wise treaty process that would best balance the working operations of the political departments would be. And that process would allow the President, of course, to take the lead in treaty matters, but requiring him to consult with the Senate. In John Jay's words, this collaboration, quote, provides that our negotiations for treaties will have every advantage that can be derived from the talents, information's integrity, and deliberations of the Senate on the one hand, and from secrecy and dispatch secured by presidential action on the other. Now, during our Constitution's first century and a half, the major debate swirled around the supremacy of federal treaties and agreements over state law, a dispute that was not finally settled by the Supreme Court until the late 40s. By the 50s and 60s, however, with the rise of the United Nations and Bretton Woods systems, the battle for dominance over treaty making within the federal government took center stage. And by the late 60s, the President had largely won that battle by using a variety of techniques, particularly the executive agreement, to lead the United States into the era of multilateralism. Now, this action was controversial, but I think two crucial features of this era are worth mentioning. First, that with few exceptions, Congress authorized the President's practices in the 50s and 60s, whether by Senate ratifications, prior or subsequent statutory approval, or appropriating funds to implement our participation in international organizations. Second, and equally important, the Supreme Court judicially validated that trend on the merits, starting with the 1937 and 42 decisions in U.S. versus Belmont and U.S. versus Pink, and concluding in 81 with a decision in Dames and Moore versus Reagan, which upheld the constitutionality of the Iran hostage executive agreement. Now, when we jump ahead to the late 70s and 80s, we witness a strikingly contrary trend, namely America's flight from, rather than toward, multilateral cooperation in international organizations. Because if the 50s was America's era of treaty making, then the Reagan years, the 80s, have just as surely been our years of treaty breaking and treaty bending. As in the 50s, the President has increasingly led the way without securing prior congressional consent by developing a whole new range of treaty breaking and bending techniques. But in three absolutely crucial respects, these years, the treaty breaking and bending years, differ from the treaty making years of the 50s. First, in contrast to the 50s, where the President used his power to enhance multilateral cooperation, in the 80s, he has unilaterally terminated or broken existing commitments without consulting either Congress or our treaty partners. Second, by and large, neither the Senate alone nor the Congress acting as a whole has authorized what he's done. And third, the Supreme Court has not validated treaty breaking or treaty bending on the merits. Now, this third point becomes clear when we look at the Supreme Court's summary decision in 1979 in Goldwater versus Carter, where the court refused to hear Senator Goldwater's challenge to President Carter's decision unilaterally to terminate our mutual defense treaty with Taiwan in accordance with its terms. Now, in that case, only one justice voted to uphold the President's authority on the merits, and then only because the issue there was a recognition question which fell within the president's plenary authority. But the Reagan administration has gone on to read Goldwater for far, far more. After Goldwater, if the president hasn't liked a treaty, he's unilaterally terminated it without congressional consent, as this administration did, for example, with our acceptance of the compulsory jurisdiction of the World Court, with respect to the Treaty of Friendship, Commerce, and Navigation with Nicaragua, and our membership in UNESCO. When a treaty's terms have prevented a president from terminating it without giving 6 months' notice, then we've evaded that restraint by purporting to modify it without congressional consent, as we did for 2 years with respect to our acceptance of the World Court's jurisdiction 3 days before we were sued there by Nicaragua. When the president has sought to ratify a treaty without really ratifying it and really subjecting our conduct to international examination, he's used the technique of non-ratification ratification, what I like to call the Swiss cheese ratification, namely submitting the treaty for advice and consent, but with so many declarations, reservations, and understandings that the exceptions gut the acceptance, as the president did, for example, when we finally ratified the Genocide Convention, and as I understand is happening now with the Torture Convention. And finally, the executive branch has even used executive agreements to undercut existing multilateral treaties, as happened when Secretary Baldridge made a side deal with Japan that authorized them to evade the zero quota which the International Whaling Commission had previously imposed against the killing of whales. Now, on the treaty-making side, the administration has been even more creative in developing techniques to amend or create treaty obligations without congressional review. When the president has not wanted to be bound by a multilateral treaty, he's refused to ratify it, then selectively complied with various provisions as a matter of customary international law, a policy pursued, for example, with respect to the 200-mile exclusive economic zone provisions of the Law of the Sea Convention, and until last year with respect to the warhead limits in SALT II, kind of a line item veto approach to treaty compliance. When he wants to evade congressional authority with respect to international trade, then he makes an agreement and calls it something other than agreement, like a voluntary unilateral export restraint, in order to cut an import quota deal with Japan on cars and steel. And obviously the most dramatic and well-publicized example, when the president wants to amend an existing treaty, for example, the 72 ABM treaty to accommodate Star Wars, he's done so without consulting Congress, the Soviet Union, or our Western allies, by choosing to reinterpret it, quote unquote, giving it a broader reading, after having interpreted it narrowly, by the way, for the first term of his administration, based on a secret negotiating record that wasn't presented to Congress when it first advised and consented to the treaty in '72. Now, in short, in the last 7 years, what we've witnessed is a dramatic executive effort to aggrandize the treaty process and to exclude Congress from all 3 phases of it. Now, even this short historical review should make clear that this administration's approach to the treaty power has strayed a great distance from the original Federalist vision of a constitutional process that involves the Senate and the President acting together. The executive branch's unilateral acts, which, as I said, have occurred largely without congressional authorization or judicial validation, contradict both the framers' legal vision and their prudential vision that the President and legislature should, quote, act as checks upon each other so balanced as to produce security to the people. Now, I wish I could say that the executive branch's rejection of the Federalist vision, if it hasn't been good for Congress, has at least been good for the country, or for the presidency, an institution for which I used to work and for which I have abiding concern. Unfortunately, my impression is that the net effect has been quite the opposite. First, let me make clear that the United States is a party to a network of closely interconnected treaties. For that reason, apparently hasty administration decisions to bend or break one treaty have forced it into vicious cycles of multiple treaty violation. For example, the administration's effort to divest the World Court of jurisdiction over the Nicaragua case through treaty modification, which would have been unnecessary had the court truly lacked jurisdiction, weakened our jurisdictional case, led to our loss on jurisdiction, which led to our decision to withdraw from the case, and another treaty breaking, namely termination of our acceptance, which led to the adverse judgment against us on the merits, and now another violation, Nicaragua's claim that we don't pay our international judgments. Second, our original decision to sign the SALT II treaty with the Soviet Union, a treaty that sets numerical limits on offensive weapons, was premised on the assumption that both parties would abide by the ABM treaty, a treaty that prevents development and testing of territorial defensive weapons. And the notion was that if there were no defensive weapons, there would be no need for an offensive buildup. Now, by unilaterally reinterpreting the ABM Treaty to permit our development and testing of precisely such a defensive system, namely SDI, the administration has encouraged reciprocal Soviet violations of the ABM Treaty, forced our own decision to abandon the limits on offensive weapons in SALT II, which happened last year, and has prompted the Soviet Union's now demand for strict compliance with the ABM Treaty as a condition to entering any START treaty on long-range missiles. In other words, this wave-on-wave of U.S. treaty breaking and bending has created a worldwide impression of a United States that's contemptuous of international treaties and institutions at precisely the time that we need to mobilize those same institutions to help us address problems we simply cannot address by ourselves. For example, the problem of trade imbalances, which we can't solve by ourselves, currency coordination, international terrorism, as Judge Sofer has referred to so many times, joint sanctions against Iran and Libya, and security policy in the Mideast and the Persian Gulf. Now, similarly, the administration's decision to avoid consulting Congress before modifying, breaking, or bending treaties has alienated that institution at the time that the president needs it most to implement the most basic elements of his foreign policy. In the area of arms control, the ABM Treaty interpretation battle between the Senate and the administration has had at least 5 counterproductive effects for the executive. First, it's alienated key senators who are crucial to the ratification of any INF treaty or the 2 nuclear test ban treaties that are currently on the Hill. It's invited other senators to call for the negotiating record of the INF treaty or to threaten to put understandings on the text of that treaty, thus potentially delaying ratification. It's threatened to make major inroads into the Department of Defense authorization for Star Wars. It's jeopardized the principle of executive privilege by triggering waivers on a whole range of secret negotiating documents. And fifth, it's limited future negotiators' abilities to engage in off-the-record negotiations, which might lead to breakthrough in future arms talks. Now, in the same way, the administration's position in the Nicaragua ICJ case has hamstrung our ability to participate constructively in the Central American peace process, and along with the Iran-Contra affair, has severely damaged the president's ability to secure additional Contra funding. And in the area of international trade, an area where the president operates largely pursuant to authority delegated to him by Congress, Congress's growing distrust of the president has led to a new trade bill that imposes unprecedented constraints on the president's ability to negotiate in the new GATT round, and may still lead to the scuttling of the U.S.-Canadian Free Trade Agreement. In sum, the administration's recent efforts to expand executive power in the treaty area have disserved the very ends that those efforts were designed to promote, namely the preservation of executive power in foreign affairs, and secondly, preservation of America's ability to lead in the community of nations. Now, in the nanoseconds that remain, let me conclude by saying that this society has commonly applied 3 standards to judge both the constitutionality and the wisdom of government conduct. First, the fidelity of that conduct to the Federalist vision. Second, the impact of that conduct on executive power. And third, the extent to which that conduct furthers the national interests. Let me suggest that under each of these 3 standards, the administration's treaty practices must be judged a failure. Unlike some, I don't believe that original intent must be slavishly followed, but I do believe that there was considerable wisdom in the framers' original insight that the president and Congress both have an important role to play in the treaty process. Of course, the president must speak for the nation and lead it in its external affairs, but in close consultation with the Congress, which is closer to the people and more attuned to how foreign policy initiatives will affect other interests of national concern. I think it's very unfortunate that this administration's failure to heed the framers' legal and prudential insight has helped to hamstring the president in his relations with Congress and the treaty partners at this very critical time in our foreign affairs. Thank you very much.
I gather Professor Coe is largely in agreement with Judge Sofer. We are running into our question period now, according to my schedule, which of course means we're way over. But I understand that Professor John Nowak is known for his brevity. He's a professor of law at the University of Illinois, where he got his law degree. He clerked for Justice Walter Schaefer of the Supreme Court of Illinois, He's a co-author of books on constitutional law, and was chairman of the American Association of Law Schools Constitutional Law section. He's a distinguished professor of constitutional law, and we're delighted to have him. And Professor Nowak, you have 10 minutes, 10 minutes only.
Thank you, Judge, I think. It's good to be here, and we'll certainly try and stay within the limits for a lot of reasons. Don't want to wear out our welcome. In Illinois, there's the story that when Governor Stevenson came back from his first loss to President and then General Eisenhower, or General and then President Eisenhower, woman in a central Illinois town said to him when she saw that it was December and he had a very nice tan, that you lost because you spent too much time vacationing. He said, no, this tan's from making outdoor speeches in California and Florida. And she said, well, then I guess you lost because your speeches were too long. Try and keep within the time limits and indeed address a little bit different subject, bridging the Harold's and Judge Sofer's presentations about the role of the judiciary here. It seems to me that there are two separate questions in every constitutional case or every constitutional issue. One for you, me, or a member of a court is what we think the quote, right, close quote, constitutional interpretation is. And the second is whether there is such a clear basis for constitutional ruling that the judiciary should feel free to impose its will on the other branches of government. This is especially important in the area of treaty making, breaking, bending, whatever you want to call it, and the Constitution. There's some good arguments for presidential power going all the way back to original intent, and one would cite articles by Hamilton under the name pacifist for a strong executive role. It's an equally strong set of arguments for legislative power that Harold cited with articles by Madison, whose silhouette adorns the hall under the name Helvidius. It's a close question. It's a tough question. It's a question that shouldn't be resolved by the judiciary, because it seems to me clear that that compromise between those Hamilton and Madisonian views is one in which the decision-making is left to a balance of power between the legislature and executive on the most practical of bases. Now, it's true that the judiciary is not excluded from all treaty cases. After all, in 1789, many of the framers of the original Constitution passed the first Federal Jurisdictional Act, which gave the Supreme Court jurisdiction over cases in which treaties had been invalidated in some other court. We don't know whether they meant really independent review or just an attempt to always ensure that treaties were upheld by the federal courts. So there's some cases where the judiciary may get involved, and it seems to me in those cases we need to recognize, as in perhaps all constitutional cases, that there's three types of issues that the judiciary can face: federalism, separation of powers, and the enforcement of specific limitations on government powers expressed in the Constitution. It seems to me that in this area, the judiciary is only justified in ever making a constitutional ruling based on specific limits on federal power. That means, first of all, that the judiciary has no role in limiting any treaty, any executive agreement, or any executive action in the name of federalism. To the extent that the 10th Amendment or the structure of the Constitution shows some inherent state and local government sovereignty, that sovereignty relates to domestic decision-making. Of course, we all know Justice Holmes' opinion for a unanimous court in 1920 in Missouri versus Holland taking that position, and I emphasize the date 1920. This was not an opinion by the Warren Court at the height of making federal power supreme over the states. This was an opinion written for the court at the time at which it was most strongly defending states' rights than at any other point in our history. And yet Holmes said for a unanimous court that when it comes to congressional statutes effectuating treaties, or when it comes to the nature of treaties, there is no subject matter limitation. That the nation was meant to be a true sovereign when it enters the area of foreign affairs, and it can carry out those agreements without worrying about reserve powers of the states. Now, does this mean we could have an executive agreement or treaty giving away half of the state of Texas to Mexico? Of course not, because there's specific limits in the Constitution about federal changes regarding the land area of states that would be enforceable, so that we could limit that, or the taking of property from states with the Fifth Amendment takings clause. But if it's a concept of somehow the federal government has overreached in terms of the scope of the treaty or executive action, such an argument should be automatically rejected. Second, and the concern that's been raised in the first two presentations, separation of powers. Again, I think the judiciary has no role in resolving separation of powers disputes between the president and the executive here. To the extent that the judiciary is ever justified in making a separation of powers ruling, it can only be justified on the twin basis that, number one, the express language of the Constitution in Articles 1 and 2 seems to separate certain types of legislative and executive powers, and number two, that a blending of those powers somehow makes it difficult for the electorate to make each branch electorally accountable and keep it in its place. Those principles clearly do not apply in this area. The constitutional text clearly shows a blending of powers between the executive and the legislature. Not only the Senate's role in ratification, but the fact that most treaties cannot be carried out without legislation. The president or the president and the Senate may commit us to X million dollars per year, it would seem, in foreign aid through a treaty or executive agreement. Would that authorize the actual dispensation of funds? Of course not, because there's a specific check in Article 1 that requires the involvement of the House of Representatives in any appropriations bill. So the specific limit regarding appropriations could be enforced. But when the president bends a treaty or breaks a treaty or uses an executive agreement as an alternative to the treaty, there should be no judicial recourse to limit presidential power. Now, some would say that I have there sold out to the Hamiltonian view and an imperial executive. Not true, because the legislature is left with a variety of remedies. It can pass inconsistent statutes. It can take a variety of practical actions against the president, everything from limitation of the president's authority in the area of simply not passing legislation the president wants to the ultimate weapon of impeachment. Now, that is a messy process, having the legislature have to respond through legislation rather than court action. After all, as the old saying goes, two things that no civilized person would ever want to watch being made are sausage and legislation. But the legislative response, the political response, is the only constitutional response because there is no specific definition of the roles of the president versus the Senate. Some specific consequences that flow from this view, that there is no judicial role in federalism or separation of powers decisions. Number one, the United States government can never be made subject to international law by a federal court unless the Congress and President have agreed to submit themselves to international law. Any other conclusion would result in a judicial decision-making regarding the proper scope of treaty powers. That's the reason why the Supreme Court in the 1800s, despite the fact that many professors, or some professors, not all of them from Yale, attack the view today, that as between a treaty and an inconsistent federal statute, the last in time prevails. There are some professors today who would like to say treaties somehow should prevail over statutes. No, said the Supreme Court in the 1800s. It said the United States as a sovereign has a right to totally disregard treaties. We may be subject to some practical consequences around the world, but not judicially enforced consequences. And that applies as well to executive abrogation of treaties. No nation should be able to sue us because we have failed to meet a mutual defense treaty or to meet some treaty obligation to them. We should be able to withdraw from the jurisdiction of the World Court without having to worry about a federal judicial declaration that that action is improper or unconstitutional. Flowing from this, a second point that under no circumstances would, and I know that the following according to the majority of the Senate, will mean I should never be on the Supreme Court of the United States, even though I've never smoked marijuana. And that is that under no circumstances should there ever be congressional standing. Not ever, never. If congresspersons are going to court to claim that an executive action is inconsistent with a treaty, what they are telling us is, look, we didn't have the political muscle in the legislature to respond through legislation. We couldn't respond through the process in Article 1. So we want to take an end run through Article 3 by trying to claim that even though we lose through new legislation, we ought to win because we get 5 of 9 people in robes to agree with us. It seems to me that that's a totally unjustified judicial intrusion into the foreign affairs authority of this country. Next, that in the absence of a clear conflict with a specific provision in a treaty or a statute, executive agreements are always to be upheld unless they violate some specific provision in the Constitution. This goes well beyond the presumption of validity in Dames and Moore versus Reagan. Perhaps it is that the president never should have an executive agreement power. Perhaps we ought to take a Madisonian view. That view should not be enforceable by the judiciary because there's no specific limit in the Constitution that would restrict the presidential power. Now, if we had a case where the judiciary could not avoid ruling on a conflict between an executive agreement and a treaty, if the conflict is clear, that is, it is clear from the language of the statute or the language of the treaty, not from some concurrent resolution, not from some legislative history. As Judge Starr of the D.C. Court of Appeals has written, to ask courts to interpret statutes or treaties through an examination of the intent of Congress, you might as well ask them to go in the back room and consult their crystal ball. They should be enforcing the specific terms of the treaty or executive agreement. If we have a suit involving private rights, and not being tort class, I won't make up 12 bizarre hypotheticals. That's why we make law reviews in torts class. If we have, for instance, a bank holding a specific amount of money, and person A says, I own the money, and person B says, I own the money. The bank files a federal interpleader to declare who it really owes the money to. In that type of case, if person A would own the money under a specific provision of a treaty or statute, person B would hold the money under either an executive interpretation or executive action, person A should get the money. That is, when there is a clear conflict that involves private rights, that is not a question of making us meet our treaty obligations to a foreign country. In that case only, the court will have to rule, and it should rule for the treaty or statute. Why? Because those are the only two of the three, between treaties, statutes, and executive agreements, that are recognized in the Constitution. Since statutes exist in Article 1, treaties in Article 2, the court says we simply have to follow those. Where it is unclear, however, in terms of the meaning of the treaty or statute, the court should defer to the executive as it has no specific limit. Now, I know that this may seem to some to somehow remove the judiciary in times of great stress or need for judicial help. But as one of my favorite authors said, if this country is committed to constitutional principles, you don't need a court to save it. And if this country turns its back on principles in the constitutional process, no court can save it. And you can attribute that quote to either Learned Hand or Joe Biden. Thank you for your attention.
Our last speaker is Justice Rocky Rees, who is the Chief Judge of the High Court of Samoa. Prior to that, he was a Special Assistant to the Attorney General in a crucial post at the Justice Department. He has been a distinguished professor of law at Texas Law School and a thoroughly interesting, provocative, and thoughtful scholar who we're delighted to have here today. Rocky?
I should add that I haven't really used my childhood nickname professionally, but other people do. When I moved to the Southern Hemisphere, I decided I had a unique opportunity. One, nobody knew me there, and also a unique constraint, which is I've found that throughout the Southern Hemisphere, there's a tremendous fascination with nicknames. And they can be distracting, and when the nicknames happen to be the same as action movies, there's even greater fascination. So I've managed to get by as Grover Joseph Rees in Samoa, and every once in a while somebody calls up on the phone, and I have to explain to my secretary. But if this is being beamed into third world nations, then I'd like it, for the record, to be established that I am Judge Grover Rees of the High Court of American Samoa. The couple of brief comments on some of the things that have been said earlier. There has been a debate raised here by Brad Reynolds yesterday on whether, contrary to what we've all been thinking, Congress may be the most dangerous branch of government rather than the judiciary. And Brad made an impressive case in terms of some of the specifics, but I think that we can still safely say that the judiciary is the most dangerous branch per capita. With regard to to Professor Nowak's chances for the Supreme Court, it isn't so much that you have to say whether you smoked marijuana or not. I think the test would be that if you are against congressional standing, there is a conclusive presumption that you must have been smoking marijuana, at least if you said it at the hearing. I think Judge Ginsburg was a brilliant choice, but I had another idea. People were worried about having a bipartisan approach to this problem, and I decided that the ideal compromise after Judge Bork had been defeated, the thing that ought to make everyone happy, is that President Reagan should have nominated Senator Biden to the High Court, but given him a copy of all of Judge Bork's opinions. With regard to treaty breaking, bending, and so forth, I guess the theme of my remarks is it didn't start with so fair. With the question of interpretation that Professor Coe has been emphasizing, it seems to me, is a sideshow in what I would acknowledge to be the gradual aggrandizement of what was supposed to be a shared power between the executive and the Senate into a power in which the executive dominates. And with interpretation, I happen not to have very much problem with what the Reagan administration has been doing. As Professor Nowak points out, a lot of these problems institutionally, practically, cannot be resolved by courts, at least can't be resolved by courts without mangling some of the traditional ideas we've had about exactly what a lawsuit is. I don't happen to think that there ought to be such a thing as the political question doctrine in this or any other area, in the sense of a great big hole in Marbury versus Madison, that when the court gets up to one of these sensitive areas, it should just stand aside and let the rough and tumble of the political or international arena create results that otherwise would be thought to violate private rights protected by the Constitution or by statutes. I do believe that most of these problems turn out to be non-justiciable because they don't involve private rights, because they do only involve institutional arrangements for which other safeguards than judicial review were provided in the Constitution. And when you do have a conflict simply over an institutional arrangement, as Professor Nowak points out, Congress has lots of weapons. Congress has lots of ways, if it's willing to use them, to prevail in that kind of battle over the executive. Indeed, many weapons short of the impeachment power. The appropriations power is the obvious example. Professor Coe finds that disturbing. He says that it's too bad that the executive has been doing all these things because A, it keeps us out of a lot of multinational agreements. Well, reasonable people can differ about whether that's a good or a bad thing. And B, it has hamstrung the president in his willingness to, in his ability to work with Congress. Well, again, that shows that it's not as one-sided as it might be. Congress does have the ability to respond, and Congress has the right to respond. And it seems to me that's all there is to be said about interpretation, at least in the absence of a definitive interpretation, as the courts have held judicial interpretations to be with regard to a particular problem. It is the constitutional obligation of each branch of government. It's the constitutional obligation of the president. It's the constitutional obligation of each member of Congress to do his or her best to protect the Constitution. And people have got different ideas about what that means. And that kind of conflict is simply going to be inevitable. When the president is negotiating a new treaty, he's got to look at the old treaty and the other constraints on any new treaty and try to figure out what they mean. And he doesn't have any obligation. The case with the delightful name of 14 diamond rings versus the United States, it seems to me is just axiomatic that the president doesn't have to be bound by a Senate resolution after the fact saying this is what we or our predecessors in that previous Senate meant. It might be persuasive evidence, but there's just no constitutional principle with a large or a small c on which you can say that he's conclusively bound by it. Similarly, the Senate doesn't have to be bound by the president's interpretation. The Senate does not have to ratify what the president does. The Senate doesn't have to, the House for that matter, doesn't have to appropriate money for things that the president does that it believes are unconstitutional. But in the first instance, just for practical reasons, in matters having to do with negotiations, that's an executive function, and the executive's opinion is going to prevail for a while. Now, again, Professor Nowak makes an important point. Whether we can get away with it is a separate question from whether it's the right interpretation. And the president has an obligation to try to figure out what the right interpretation is. And I would disagree a little bit with Judge Sofair and say that if I were the president, if I were in the State Department, I wouldn't look just to explicit understandings. I would try to figure out what the understanding really was. I would try to figure out what people really thought. And what was said by an executive to the, a representative of the executive to the Senate would be one piece of evidence. It would only be one piece of evidence, and the other evidence raised by Judge Sofair would be important too. But I think that it is overly formalistic to say that the Senate has to have an explicit understanding before legislative history should even be consulted in trying to figure out what the treaty means. And that's about all I have to say about interpretation. Except to observe that not contrary to what Professor Coe says, I just don't mind the fact that, in fact, in the treaty power, the President and the Senate each do have a line item veto. They've got that as a result of international law. That's what treaties and reservations and to some extent understandings are about. I think that what the president did, what the executive did with regard to the Genocide Convention, which, by the way, they worked very closely with Senator Lugar, who was the chairman of the Foreign Relations Committee on that. I think that was a fine example of cooperation at work. Now, it's true, it didn't come out the way that the people who were for unreserved ratification of the Genocide Convention wanted it. So if the desideratum to be maximized is we got to be in as many international organizations as possible, and we've got to have as few limitations on the abilities of these organizations to do things to us down the road as possible, then that wasn't a good idea. But there simply isn't anything wrong with ratifying a treaty with reservations, and that the executive is the one who sent it to the Senate with reservations is, in my view, no worse, no more unconstitutional or counter-constitutional than if the Senate thought the reservations up for itself. As a matter of fact, I think the executive came up with some of those reservations because they were pretty sure they couldn't get it through the Senate without them. That, it seems to me, really runs counter to Professor Koh's point. Now, let me shift, however, to what I think is the real problem and the real example of the executive taking over the treaty power, and one which Professor Koh glossed over, perhaps because it has helped us to entangle ourselves in international organizations rather than to get out of them. And that is the use of the executive agreement in many cases in which I think the framers and ratifiers of the Constitution anticipated that there would be a treaty instead. Now, of course, there are going to have to be some executive agreements, and some executive agreements are unproblematic constitutionally, where all the president is doing is exercising a function which either is his constitutionally or which has been delegated to him by Congress. You don't need a separate treaty. When you're talking about a trade agreement pursuant to earlier general legislation, or when you're talking about something to do with how many people you're going to have at the embassy and how many people they're going to have at the embassy. Those aren't the kinds of things that I'm worried about. But the outstanding example, and something that has never been matched since in terms of its audacity, was the Litvinov Agreement, the case that was involved, the agreement that was involved in Belmont and Pink, the two famous cases that said pretty much you can do anything by a sole executive agreement that you could do with a treaty, at least in the absence of explicit countermanding legislation. And the court didn't even add that reservation, although most scholars have. What happened in Belmont and Pink was that we recognized the Soviet Union. Prior to that, the Soviet Union had tried to nationalize everyone's assets who had been a Russian citizen. Some of those assets were in other countries. The New York state courts had held that assets in New York that were always in New York and that on the records of the bank were shown to belong to particular people still belonged to those people even after the Soviets claimed that they had now become the property of the proletariat. As part of incident to the recognition of the Soviet Union, President Roosevelt agreed that the United States would become the assignee of all of those claims that the Soviet Union had against former Soviet citizens or former Russian citizens with money in the United States. They then relitigated the case. The New York courts came out the same way. They said the United States stands in the shoes of its assignor. As a matter of New York state property and contract law, the money still belongs to, I guess, Belmont and Pink. It still belongs to the people who owned it before. The Supreme Court of the United States held, no, this is a valid executive agreement, partly because it was incident to recognition, and I'll get to that in a moment, but partly because we all know that it's a big world and that there's a need to act quickly and that the United States government is sovereign, and that sort of means that the executive is sovereign. And as Professor Henkin said, well, they might not want to reconsider the result, but they certainly would want to reconsider some of their enthusiastic language about the Litvinov Agreement. It was a paean to executive power. And then it said almost incidentally, since we found this was a valid executive agreement, state law has to fall. Now, that is an extraordinary doctrine, and it seems to me that that we should still be noticing that. It goes a lot further than Dames and Moore went, because in Dames and Moore, there was deemed to be implicit congressional acquiescence, and there were a number of things that Congress had done that it seems to me made a pretty convincing case for that acquiescence. There was no such thing, and it's very unlikely that you could have gotten the Litvinov Agreement empirically through Congress, or at least it is problematic. And they didn't try. They didn't try to do it by a treaty. They didn't try to do it by an executive agreement plus a statute. It was a sole executive agreement. Now, let me talk about a couple of possible justifications for using executive agreements in the way that they were used in the Litvinov assignment, that they've been used since, that do somehow fit them into the constitutional framework. The justification advanced primarily by the cases themselves was the Curtis Wright justification. The case of the United States versus Curtis Wright, where the argument went like this. The United States has sovereignty. Sovereignty is apart from whatever happens in the Constitution. It's not contractarian, counter to what Madison and others told us. Sovereignty always was and always will be. And where the Constitution doesn't say anything else about it, that sovereignty belongs to the executive. And the justification for that in terms of text was the part of the Constitution that says the executive power shall be in the president. The list of things after that was deemed not to be inclusive, but to be illustrative. And if there was some power that wasn't mentioned anywhere else, that automatically belonged to the president. And all of the arguments about the need to deal with other countries and so forth came into that. Again, I think that Curtis Wright was not only unconstitutional in the sense that it ignored the Constitution, it was counter-constitutional, because what our Constitution was supposed to be about was dividing up sovereignty, and the idea that somehow there is this thing called sovereignty which pre-existed and which still overarches and which automatically resides in the executive. I mean, it's just as bad to say that it automatically resides in the judiciary, which in a number of areas we do today. But it seems to me that ignores the careful balances that were put together in the Constitution. I just don't think that justification works, especially when you then start defining the executive power, this unlimited executive power, much as Metternich would have defined it. What our Constitution was about was to be against that. I don't think that justification works. The second justification was that it was incident to recognition. And if you want to make this executive agreement power incident to recognition, that is a limiting factor, I agree. Even so, that somehow in the process of recognizing a particular government, you can override state law is an intriguing concept, and a concept, it seems to me, that needs a justification that was not given in Belmont and Pink, and that has not been given. You got to remember that the only thing that the Constitution actually says about this is that the president shall receive ambassadors. Now, maybe they haven't taken that any further than the Commerce Clause has been taken. Maybe we do have to say this has all been judicially validated over the years, but it's quite possible that what the receiving ambassadors clause meant was it was simply a roadmap. When an ambassador comes to the United States, who is he supposed to visit? Well, it was not clear at the time what kind of government we were going to have. It was not clear that we were not going to have a quasi-parliamentary system. And to say that the president receives ambassadors is just a different way of saying he is the head of state. It doesn't even say he's the head of government. In England, the Queen receives ambassadors. And you can argue that the original intent of that clause had absolutely nothing to do with deciding which ambassadors to receive. But even if the implied power, even if the power to receive ambassadors implies the power to decide which ambassadors to receive if there are two claimants to sovereignty in a country, the idea that you can incidentally break treaties and override state law is quite a jump. And it's a jump that wouldn't make it in other areas of constitutional law, that would not be regarded as automatic. And it seems to me that Justice Brennan's argument in the Taiwan Treaty case does carry that a step further, because in the Taiwan case, it wasn't a case of there was a Chinese government, we had a treaty with the Chinese government, President Carter decides to recognize a new Chinese government, therefore, incidentally, he's obviously got to break some relations with the old one. No, when we confected that treaty, everybody already knew there were two Chinese governments. That was a treaty obligation that said, we're going to do some nice things for this Chinese government. And it simply said that the United States can terminate the treaty. To say that there is an automatic presidential power to terminate the treaty, aside from whatever other arguments there are about terminating treaties, to say that because it's incident to recognition, that the president can automatically terminate a treaty, it seems to me needs a justification that hasn't been given and is inconsistent with the scheme in which the president and 2/3 of the Senate make treaties. It seems to me there is a third justification that has not been widely advanced, possibly because people don't think they need it, because they're satisfied with the other two. And that is the justification that was alluded to by Professor Van Alstyne yesterday in talking about the War Powers Act. And this is Justice Jackson's analysis in the Steel Seizures case, that where there has been, in an area that the executive practically dominates, as in foreign affairs, that just as a practical matter, the executive is the one who's got the time to spend on it and who's in the right place, that where Congress hasn't complained, they are deemed to have acquiesced, and they are deemed to, and therefore the president, when he acts in an area like foreign affairs and Congress hasn't said no, we should treat that as though there were an act of Congress saying that he can do it. I think that is a generally sound analysis, and I think that it may be applicable here. The problem is that it gets you into a thicket that I've always hoped intellectually to be able to avoid, which is, are there certain things that can only be done by a treaty? This is some of the early debates that Judge Sofair was talking about. Most people who pay attention to this sort of thing today have decided that the president with an executive agreement plus a joint resolution or a statute gets you anything that a treaty could get you. That whether or not a sole executive agreement would be enough, an executive agreement plus a statute is a complete substitute constitutionally for a treaty. There is an argument to be made that under the original scheme, by setting up the special provision for treaties where you couldn't do it with both houses of Congress in a simple majority, you needed 2/3 of the Senate, there must have been some things they wanted to reserve. The problem is that once you assert that, you get into a line drawing problem. What is it exactly that would be, you have to do it by a treaty, you have to do it with the president and 2/3 of Congress, you can't do it by the president plus both houses of Congress, and therefore you can't do it by the president alone on the assumption that Congress has gone along. Don't have time to get into what those things might be, but the germ of the idea would be that if it really is a question of foreign relations, of an agreement between nations, as opposed simply to domestic regulation that we may be doing, knowing full well that this is something that England or Canada or the Soviet Union wants us to do. If this really is an agreement, that perhaps it needs to be done by treaty, and perhaps that ought to be re-examined. And again, I want to close by by stressing that there are three different questions that have to be asked with regard to answering that question. If I'm the president and I'm trying to decide whether to do something by treaty, by executive agreement, or by executive agreement with a statute, the calculation seems to have had a lot to do with which can I get away with. It is said that one of the SALT treaties was ratified by resolution with a simple majority in each house because President Carter was pretty sure he could get a simple majority in each house and wasn't sure he could get 2/3 of the Senate. It seems to me that's not allowed to be the question that you ask in deciding which of those things to do. If it was a matter of foreign relations, of an agreement with a foreign power, and you knew you couldn't get 2/3 of the Senate, you still might have to try. That would be true even though we stipulate that the courts aren't going to get involved in it, and perhaps especially if we stipulate that the courts aren't going to get involved in it. Because in those areas that for one reason or another are non-justiciable, there's, if anything, a higher obligation on the part of the other branches to self-police and to try to figure out what the Constitution requires, what the structural provisions of the Constitution are there for. And in this area, I think there's a lot of room for examination of conscience by the executive as well as by the legislative. We've kind of gotten into a situation in other areas where constitutional arguments are just that. They're rhetoric. If you're against a bill, you argue that it's unconstitutional, and you don't have to be too careful about your argument because you know the courts will take care of it one way or the other. If you're for a bill, similarly, you don't have to worry too much about the Constitution because the courts will take care of it one way or the other. In these areas that are unlikely to be decided by courts, it seems to me each branch has a very high responsibility to try to figure out if there are constitutional implications, including especially these structural constitutional implications, and to try to abide by those, even though they know they'll get away with it if they don't. The third question that you have to distinguish from these other two questions is it good for the country? In other words, even if I think I can get away with something as the president or as a senator, even if I think that my view will prevail, and even if I think it's good for the country, and that it would be very bad for the country or for the world, Professor Coe would no doubt say, that my view not prevail, I still have to ask that constitutional question. Even though in answering the Constitution question against what I want to do, I will be imposing a restraint on myself that neither the courts or any other body are going to impose. And even though, in my view, it will be bad for the country and or the world, if having a Constitution means anything, it means that I have to abide by the answer to that constitutional question, even when the two other questions come out the other way. We hear often, the Constitution is not a suicide pact. Usually when we hear people say that, what they really mean isn't that if my view doesn't prevail, the whole country's going to be destroyed instantly. They mean that things are going to be a hell of a mess if my view doesn't prevail. Therefore, let's not look too carefully at the Constitution. To rephrase that argument accurately, therefore, people who say the Constitution is not a suicide pact are saying the Constitution is not an inconvenience pact. But it is. The Constitution is precisely an inconvenience pact. That's the definition of a Constitution. And it seems to me that way before President Reagan, way before the current Senate, in the foreign relations area, presidents and senators would have been well advised to keep that in mind. Thank you.
We do not have a great deal of time for questions, but I would like to put one question to all four panelists, one specific question. Or let me put it this way, to three panelists. Professor Nowak took a very strong view about the role of the judiciary. I'm not sure that Professor Coe or Grover Rees, sorry, I've got a note here. Oh, it's only a housekeeping note. There'll be a short break at the close of this session for 10 minutes. At 11:15. I have 2 minutes to ask the question. I'm not sure from Judge Rees's analysis whether he would agree with Professor Nowak. I don't think Professor Coe would, but I'd like to ask them specifically, and also Judge Sofer too.
Well, I will say that I have actually written in this area against the political question doctrine. I think the political question doctrine as a separate doctrine, or the even more elaborate version of the political question doctrine that Dean Chopra has announced, that where some part of the Constitution that's not very important to me and mine is involved, the courts should stay out of it and should let the political process work. That's an audacious and a dangerous doctrine. The political question doctrine has most frequently been invoked in areas where the Constitution was pretty clearly being violated, and there was no way around it but for the courts to abstain entirely. I think that doctrine is impossible to reconcile with the premises of Marbury versus Madison, with which premises I agree. Now, I thought that was what Professor Nowak was going to say when I heard the précis of his speech. He hedged it about, however, with enough qualifications that I think I agree with him. That is, one reason the political question doctrine has become necessary, or has thought to be necessary, is because of the erosion of all the traditional limitations on what gets to court. Most cases that have been decided as political question cases either A, shouldn't have gotten to court because of standing, or because of ripeness or mootness or something like that, or B, the plaintiffs clearly shouldn't have won once they got to court. They did not, in fact, state a cognizable claim. They didn't prove their private rights had been violated. The only thing they proved was that they didn't much like what the
Well, would you two
executive or
disagree
Congress had done.
on the Pink and Belmont cases? Did I detect that at least? Yes. Yeah, I thought you would disagree. The two of you would disagree on that.
Well, except that I think in the Pink and Belmont cases, the court, it's always hard to tell in one of these cases whether the court is talking about decision-making power or whether they're talking about the merits. I interpret Pink and Belmont as having more to do with the merits, not just the president may be acting unconstitutionally, but we're going to stay out of it. But the president somehow acted constitutionally because he's got this vast implicit executive power. In that case, I would say they should have reached the merits and held that the president didn't have all that power.
Yes, that's what I thought. And Professor Nowak, you would have disagreed with it. You would disagree with that.
Yes, I would say that without a specific statute that indicated that other parties owned the property, and with the notation in the Belmont and Pink cases that they found that the creditors' claims were satisfied, so that none of their property had in fact been taken without just compensation, because the just compensation clause would have been enforceable. But in the absence of any ability to find a specific conflict with statute or a taking of property, I agree with the judge that the opinion would have been better written by saying there is an absence of a basis for judicial invalidation, and therefore the federal action prevails, as opposed to the opinion that indicated that in fact the correct view of original framing of the Constitution was contrary to what the judge thinks. So we do differ to some extent.
Can I ask you one question
If I
about
may, I
that?
only have one question left for the other two over here.
Can I speak to the question, what you just asked?
Yes, but briefly.
Yeah.
Because I have another question for the two of you.
If the question is, can the courts resolve treaty questions, then that reminds me of the Southern Baptist minister who's asked, do you believe in total immersion baptism? He says, believe in it? Well, hell, I've seen it done. Can the courts interpret treaty questions? Yes. See, Missouri versus Holland, 1920, Belmont, 37, Pink, 42. Dames and Moore versus Regan, Sumitomo, and Cetacean Society. The only difference is every time the court has ruled on treaty questions, they rule in favor of the president. When somebody challenges the president, they don't reach the merits. Now, what I thought was very peculiar about what Judge Rees said was he said that he was happy about the Reagan administration's treaty practices, which he didn't think created an interpretation problem.
Wait a minute, Professor Coe. I'm not going to let you attack Judge Rees on that point, because then I won't be able to ask you the last question. He'll have a right of reply. And on the last question, which I don't have, which seems to me goes to a dispute between you and Judge Sofair. If I understood you correctly, and I just want to sharpen it, I don't have a view on this, of course. If I understood you correctly, you accused Judge Sofair and the administration of illegally bending the ABM treaty. If I understood Judge Sofair's last point, and I wasn't sure I did, but if I understood his last point, it would be inconceivable for the treaty to develop inconsistent obligations on the Soviet Union and the United States. That is to say, the same document, like a contract, couldn't impose an obligation that was asymmetrical, and that the Soviet Union could not possibly be obligated by the communications between the executive branch and the Senate post the signing of the treaty. Ergo, the communications between the executive branch and the Senate could not modify the agreement between the United States and the Soviet Union. Do you agree with that? If I understood Judge Sofair correctly, do you agree with that, Professor Coe?
As a matter of international law.
Yeah, well, of course.
There's a difference.
Yeah.
In commenting on the ABM reinterpretation debate, I didn't spend a lot of time on the merits. The main point that I was making was that the effect had been counterproductive for the executive branch in its dealings with Congress and our allies. But if you want to go to the reinterpretation, I think the simple point to be made is that if the treaty and structure of, if the language and structure of the treaty are clear, which 6 secretaries of defense and 8 of the 9 negotiators and President Reagan in his first term seemed to think, then the negotiating history is irrelevant. If the negotiating history is relevant, then I think the relevant question is, why is the negotiation history rather than what the Senate advised and consented to relevant? Just imagine this scenario, which is essentially what Judge Sofair puts to us. The Soviet Union says, we wanted a narrow interpretation, but the U.S. didn't want one, and therefore we're entitled to develop radar at Krasnoyarsk. Well, we would say, it's very odd. Where did you get the evidence about our intent? Now, I think what the Pandora's box that's been opened is we're making arguments about what the Soviets intended. That makes the negotiation record relevant to every treaty. That means that on the INF treaty, 100 senators are going to be digging into 6 years of INF negotiating records and putting understandings on every line of text. I think that's extremely disturbing prospect if that's the way we're supposed to go about treaty interpretation.
Judge Sofair, you have a brief chance to respond, and then I don't know if we have any time at all for questions from the audience. This latest note I got is somewhat peremptory. Well, who is the Obergruppenführer that tells me what the answer?
I'm afraid we'll just have to have a closing remark because we have run out of time for questions.
The answer is no one has a chance to respond to Judge Sofair. Go ahead, Judge.
Well, I think it's unfortunate Professor Coe doesn't know what he's talking about. The fact is that in connection with the ABM treaty, there has been a lot of very erroneous things said at a time when the administration was still putting its case together because of early statements by some administration officials about the treaty that caused a lot of legislators to get into high gear before the administration had really put out its position. But the fact is that it is not at all as Professor Coe said. Krasnoyarsk has absolutely nothing to do with any of this. Krasnoyarsk was a violation long before 1985. They had begun that treaty. And the Soviets have never accepted the restrictive interpretation. I mean, people should pay attention to what's going on out there in the world, in this Washington, D.C. People are calling an interpretation, a traditional interpretation, that has never been accepted by the other side in a bilateral treaty. It is the most preposterous characterization I have ever heard in my professional life. Now, the Soviet Union did articulate throughout the negotiations, and right up to 1978, when we started publishing our plans for strategic defense, publicly publishing them, they articulated a view of Article 2 that presented a very limited scope for the treaty that did not cover unknown devices. Thereafter, they started to articulate a much narrower view of the treaty than we had ever accepted. And that's why I referred to Jerry Smith's statement in the Senate hearings. Jerry Smith said we could develop things until we got to field testing. When we presented the Soviet Union with that theory in 1981, they flatly rejected it. Now, Senator Nunn on television just a week ago, and he is a man of honor and a serious man, when he was presented with the question, well, the Soviets have always accepted the restrictive interpretation, he stopped the interviewer and he said, no, wait a second. We all know the Soviets' position on the ABM Treaty is absurd. They've always had this absurd position that we couldn't even do research and laboratory testing. Now, I ask you, in that context, is it inappropriate for the president to ask his lawyer, what is the scope of my discretion under this treaty? And for a lawyer exercising his professional judgment and indeed his duty to his president, to tell the president, look, I looked at this stuff, and Paul Nitze agrees with me, and you can count 50 other people and put them on one scale, and take Paul Nitze and put him on the other, and I would say, wait a minute, why do these people disagree with Paul Nitze? I wouldn't be asking Paul Nitze why he disagreed with them.
Judge Sofer, you're only allowed to attack the panelists. You're going beyond the scope.
Well,
I think, and I have to cut it off at this stage because
I hope the audience looks into his statements about the ICJ. They're just factually wrong. He's got everything twisted historically.
Well, I'm glad I was able to ask both of you some mild, non-controversial questions. That concludes our presentation.